you were arrested by the Port Arthur Police Department on March 31st of 2026. And is that true or not true? I'm sorry.
True.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
I didn't know about that.
He said he didn't know about
it.
You didn't know you had community service hours. I don't believe that for a second, but I'll put not true on it. Probation goes over that your very first meeting. It's in your paperwork, but obviously you have community service. You know that now. And so if I go along with this agreement, you're definitely going to have to get that taken care of. You understand?
Yes.
Okay. Count 5 alleges that you were at a location other than your residence at approximately 11:49 p.m. March 31st of 2026. Is that true or not true? That's not true.
At the time,
he's trying.
That's when you were arrested, right?
The issue, Judge, is that he was on his way home and he got in a wreck. He was leaving before his curfew. I've explained that to him. He can explain why he was out after his curfew, but he was,
So you had a wreck while you were driving drunk.
It's 8:30. I stayed up the street.
Where were you at 11:49?
Were you at home?
I was gone. I was in the cop car.
Okay. But the reason you weren't at home before curfew is because you got in a wreck.
Yes, ma'am.
Because you were driving drunk.
Yes, ma'am.
So it's also fair to say, don't you think, that you weren't at home for curfew because it was your own fault because you had a wreck and you were driving drunk? Okay. So is that true or not true that you were out past curfew? Count 6 alleges that you provided a urine sample, which this is the same really as the other one. This says he tested positive for alcohol.
Yes,
Okay, count 7.
Same with 7, Judge. I think maybe we could just move to 8 and be finished with it.
Okay, yeah, those are the same. Count 8 alleges that you failed to submit to alcohol and or drug screening February 6th of 2026 and March 9th of 2026. And is that true or not true? And then count 9, that was count 8, I'm sorry. Count 9 alleges that you failed to pay your court assessed fees as directed. As of April 2nd of 2026, you were $685 behind. Is that true?
Yes, true.
Okay. Did you enter your pleas of true to counts 1, 2, 3, 5, 8, and 9 freely and voluntarily? And did you plead true to those because they're actually true? So this agreement says Safe P from the beginning. Am I to assume that he's already been through Safe P?
I think if the court would allow, Ms. Cole has some things to add about that and a little bit about his attitude for the court to maybe help us get off on the right track if you follow this agreement. I did also inquire with Port Arthur Police Department yesterday about that new offense. It has not yet been submitted. The court does follow this agreement. I will ask that they submit it this week so that he can enter a plea to it because I'd like it for the conviction.
For sure. How are you, ma'am?
Good, how are you?
Would you please raise your right hand? You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you.
Mr. Riley did complete the entire safety continuum. So he went from the unit placement to the residential aftercare to the 9-month outpatient aftercare. Right when I was getting ready to transfer him to another caseload, he had the incident with drinking and driving. I went and saw him at the jail, and the problem that we've had is his willingness to take accountability. So giving him another opportunity to go through the program from the beginning, hopefully he'll learn some accountability. If not, he's going to keep repeating the same circle.
You understand what she's saying?
Yes, ma'am.
And will your client waive the formal reading of the motion?
Here we are.
Mr. Riley, in clause number 23, DCCR 0262, I have a motion to revoke your community supervision. Shows that you were placed on probation June 11th of 2024 for evading arrest or detention with the use of a vehicle, 3rd-degree felony. That was an 8-year term in prison that was probated for 8 years. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense of driving while intoxicated, a Class B misdemeanor, on March 31st of 2026 here in Jefferson County, Texas. Is that true or not true?
Yes.
True or not true?
True.
Thank you. Count 2 alleges that you violated the condition of your probation to avoid injurious or vicious habits and that you tested positive for alcohol March 19th of 2026. Is that true or not true? Count 3 alleges that you violated the condition of your probation to conduct yourself in a courteous and professional manner at all times. And it states that you were belligerent and combative, refusing to comply with the directions, when just kind of what I heard a little bit today, just trying to take some responsibility, but not full responsibility. And that's just going to get you in prison is where it's going to get you because you're not going to get an opportunity like this again.
Yes.
The amount of money that it cost us to send you to safety is ridiculous. And the fact that everybody's willing to work with you and do it again means they think there's something worth saving. And that's great. And I want that for you. But it's going to take you accepting responsibility for everything in your life and making complete change.
Yes.
Is that what you want to do?
Yes, ma'am.
All right. State tender's number 1.
No objection.
It's admitted in the evidence that Mr. Riley is not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 3, 5, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to revoke your probation, but I'm not going to do that. I'm going to follow this agreement. I'm going to continue you on probation. I'm going to order that as a condition of your probation, you enter and successfully complete the SAFE program. Take advantage of it, learn from it. You should have all the tools when you get out of SAFE to never make these mistakes again.
Yes, ma'am.
Because if you do, you've already agreed to an 8-year sentence. So if you're back in here, you're looking at that 8 years that you've already agreed to. No negotiations. If you violate your probation, is the 8 years. You understand?
Yeah.
All right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I wish you the best of luck, sir. It's print. Give me just a second. And then as soon as that other case is filed, you'll have to take care of that because you won't be able to leave to go to safety until that takes place. So they'll get you over to misdemeanor court on a jail day as soon as that's filed, okay?
Yes.
Thank you, Judge.
Thank you.
Okay, I'll go.
Have a good day, son. Good day, son. Like, fun play with the others.
Ms. Holmes,
Yes, ma'am.
you've got Caleb LaFleur. Oh, you got up there in just a second, Mr. Mackin. Morning. Good morning. How are you doing? I show it, Miss French. Start checking ear with flights to see your new friends.
Oh.
I saw the pictures. Good morning. Are you Caleb LaFleur?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
So this is the one. So it's not a first.
No, we amended the indictment to 3rd degree.
I didn't write that at the top for some reason, but I see I wrote it in. All right, Mr. LaFleur, in cause number 26, DCCR 0039, you're charged with a 3rd degree felony offense of theft of property. And that is from December 14th of 2025. And how do you plead to that charge?
From December 14th?
November, did I say December?
Yeah,
Sorry, November 14th of 2025.
yes, ma'am.
Are you guilty or not guilty?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
Ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. LaFleur is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the 3rd-degree felony offense of theft of property. Sentence you in accordance with that agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Good luck to you, sir. You can go back with the bailiff.
Oh,
Your Honor, if I may, one moment. Mr. LaFleur has provided a unsworn statement taking full responsibility for this event. He does have a co-defendant who he is apparently exonerating of any responsibility, but since it's unsworn, may I ask him to review and let us know if this is in fact his statement while he's on the record?
Sure.
that's
Thank
what
you.
I'm asked to.
Thank
Yes, it is.
Okay.
Everything that's on the thing is everything that happened. You want me to read the statement or?
No, sir. As long as you're just letting us know you're under oath right now, that
Yes.
that is your statement and
That's
that,
my statement.
and everything in there true and correct.
Everything's in there and true and correct.
Okay.
Thank you, Your Honor.
Thank you, Ms. French. Thank you, sir.
Thank y'all.
So that one initially said first in the caption, and it was amended, but I didn't make that notation at the top. So I just made the notation at the top, just so it's clear that it was amended to be a 3rd. Christina Rodriguez.
Your Honor. I believe some events that have transpired might suggest she need an evaluation.
Agreed.
Okay.
It's been like a lot of stalking and harassing of patients
Mhm.
of other people.
It's detectable.
Good morning, ma'am. Are you Christina Rodriguez? And so this is cause number 17-27256, and Ms. Rodriguez is on probation, and there's been a motion filed. Ms. Rodriguez, before we do anything else on your case, just based on some information that I have, I'm going to reset your case. We're going to have a doctor do an evaluation just to make sure we have competency, and then we'll get you back in court within just a few weeks. Okay. So if they come in person or if they go over the Zoom thing that they have at the jail, just cooperate and go through that appointment with them and their questions, and then we'll see where we get from there. Okay. This is to make sure that you understand everything and that you are competent to stand trial. Okay. All right. You can go back with the bailiff. Yes, ma'am. Thank you. Oh, yeah. Brian McQuaid, Mr. Macon. Yes.
We have.
Thank you for doing that. Sorry. I had to.
No problem. I now know.
All right, sir. Again, you're Brian McQuaid,
Yes, sir.
and get it pulled up again.
June 2nd. Right, June 2nd, Anthony's, how are you doing?
Now it's spinning. Okay, so Mr. McQuaid, in cause number 26, DCCR 0402, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from March 8th of 2026. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Macon that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison that would be probated. You'd be on probation for 10 years. You would do 30 days upfront time and follow all of the rules and conditions of probation. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get it set for trial. Is there any reason, Mr. Coleman, to believe that offer would change?
No.
So I do want to make sure you understand, Mr. McWade, that once your case is on my trial docket, I don't accept this plea agreement again, unless there's some new information that the attorneys don't have or know about right now. Otherwise, if you change your mind and you want to enter a plea of guilty later, it would be either open to the court or to something other than what's been offered today. Do you understand?
Yes, ma'am.
All right, we'll get it set on the trial docket. Mr. Macon will begin preparation for trial.
Thank you.
Ms. Holmes, you've got Michael Spain.
Yes. You have some off the record on, fine.
Ms. Holmes, you've got Sasha Swofford.
Yes.
We're going on count one only.
Yes, Sharon.
Good morning, ma'am. Are you Sasha Swofford? Just stand right there.
Okay.
Are you Sasha Swofford? Answer yes or no, please. Good morning. Morning. Good morning.
Morning, Judge.
Morning. Hmm.
No, it's not documented.
Good morning, sir. You're Michael Victoria.
Yes, ma'am.
This is cause numbers 21-36410 and 21-36411. Mr. Victoria is charged with murder in each of those cases. And what is the announcement?
We have filled out a plea bargaining rejection form, in each of these cases.
All right, give me just a second. So what that means, Mr. Victoria, in each of your cases is that if you go to trial and you're found guilty, the range of punishment. I'm sorry, it's going slow.
It's habitual.
So your indictment alleges, in each of those cases, in addition to the charge of murder, it alleges that you were previously convicted of aggravated robbery, burglary of a habitation, retaliation, and another burglary of a habitation, and an aggravated robbery. All those are from the same date.
There's also a federal conviction.
I'm sorry, can you read?
So federal conviction, he is a veteran.
Okay. And so in your indictment, it alleges that you were previously convicted of all of those prior felonies. In addition, it sounds like there is a federal conviction that was after that, which would make you, for punishment purposes, if you're found guilty and those prior convictions are true, a habitual offender with a minimum punishment of 25 years if you're found guilty, up to 99 years or life in prison in each of those cases. Do you understand?
Yes, ma'am.
And in each of those cases, I have here on the tablet some documents that you've signed with Mr. Eckhart that show that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 35-year terms in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all that?
Yes, ma'am.
And do you want to reject those offers and have your cases set for trial?
Yes, ma'am.
All right. And is there any reason to believe that there would be a change or in that offer? Anything that you guys are waiting on evidence or discovery wise?
There's going to be some things that I'm going to ask Philip to request, but nothing that I think we're waiting on. Just it's not the file, but we're working on it.
Okay. I just want to make sure when we get to that trial date, obviously, the age of this case is very concerning. So I want to, once it's on the trial docket, it's going to be expected to move pretty quickly. So if y'all need anything, make sure you make those requests quickly so that when it gets to trial, we'll get that taken care of. Also want to make sure you understand, sir, that after today, I will not accept this plea agreement. If anything changes, something comes up the attorneys don't know now, then maybe that would be different. But otherwise, it's going to be a trial, or if you change your mind, you can enter an open plea or to something different. You understand?
Yes, ma'am.
All right, you can go back with the bailiff. We'll get it on the trial docket.
Thank
Thank you, Judge.
Yes, sir.
you.
Mr. Macon, you've got Brian McQuaid. Good morning. Good morning.
Good morning, Your Honor.
What did he go to now?
Yeah. It's a long story.
I'm sure he did.
We're now to the courtroom.
You missed the excitement this morning, Your Honor.
I did.
I was next door in the interview room, went to slide back and fell off the stool and my legs were caught and I couldn't stand up. So I called out, help, help. And the deputies go, what do you need? I went, help. They opened the door and,
Oh my God.
holy,
I'm glad you're okay.
no,
Good morning. Are you Brian McQuaid?
Yes, ma'am.
And this is 26 DCCR 0402. Mr. McQuaid is charged with aggravated assault with a deadly weapon. And what is the announcement?
Your Honor, he's rejecting the offer of 10 years, probated for 10 years.
Did you do a plea bargain rejection?
Yeah.
Oh, can you do it on the tablet? Where'd you find that? Yeah.
I didn't know there would be a test.
I'm sorry. I didn't know we had still paper stuff out there. We should.
I'll-
It's on the tablet. Can you do it on the tablet real
Sure.
quick? Thank you. I'll take care of it as soon as y'all do that. Just after dockets, let's go look at what else out there. Wait. I mean, they don't like this. Ms. Perazzo, you have Ava Musgrove.
Ava. Musgrove.
You all been here?
That's it.
Good morning, Your Honor.
Good morning, sir. How are you?
I'm good. So far.
It's a little early. Good morning. You're Ava Musgrove.
Yes, Sean.
And this is 25 DCCR 0048. Ms. Musgrove's case is set for trial to begin with jury selection next Monday. And what is the announcement?
So, Your Honor, I have become aware of some medical records that I am needing to request that pertain to Miss Musgrove.
Okay.
And without
Why just
knowing,
now?
well, because I wasn't aware of them until I received a report.
Okay.
And I just have to be kind of careful
Sure.
about.
Did y'all file a motion for continuance?
No, ma'am, we did not, and I apologize.
Mr. Nichols?
State's ready, Your Honor, to understand whatever concerns Ms. Rose may have.
So old. So what I'll do is reset it to the next trial docket. Whatever needs to take place has to take place before that. There won't be another reset.
Yes, ma'am.
Okay, thank you.
Thank you, Your Honor.
You can go back with the baby. Mr. Adams, you've got Travis Smith.
Yeah, yes, I think we're ready, honestly.
Private, yeah. Good night.
Good morning.
Morning.
Do you have your discovery certification?
No. Let me see.
Yeah, I think I just called.
I gotta do this.
So it's just. Actually,
It's not, you know. Yes, ma'am. And you'll need to email the attachment today to the clerk. It has to be here today. Yes, got it. Yes, ma'am. Thank you. All right, so you're Travis Smith? Okay, thank you. And so I'm going to take judicial notice of the court's file. And Mr. Smith was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for competency restoration. I received the report back from that facility. There is the forensic psychiatry report prepared by Dr. Select, dated May 13th of 2026, with the finding that Mr. Smith is currently competent to stand trial. In addition to that, there's a trial competency evaluation report prepared by Dr. Guzman, also with the opinion that Mr. Smith has regained a competency to stand trial. Is there any other evidence with regard to competency?
Not at this time, Your Honor. I've got the report.
All right, then at this time, I am going to find Mr. Smith competent to stand trial. Will he waive the formal reading of the indictment?
We'll wait, John.
Mr. Smith, in cause number 25, BCCR 1251, you're charged with the state jail felony offense of theft with previous theft convictions from August 14th of 2025. The indictment alleges you were previously convicted of theft July 29th of 2014, and then after that, December 16th of 2014. And how do you plead to that charge? And are those prior convictions true? Are the prior convictions true?
Yeah.
And did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Adams?
Yes,
Do you fully understand them?
yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached.
2 years probation, fine with bells and all Judge.
Okay, y'all filled out the 2 years state jail and 2 years county jail.
Yeah,
State-
I couldn't erase it I was gonna erase the county jail. I'm not sure which would
Okay.
be, but
All right, so it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years.
What do you think? Did the judge make the right call, or was this defendant given one chance too many? In today's courtroom, we saw everything from probation warnings and emotional second chances to guilty pleas and serious prison sentences. One decision can change a life forever, and in this courtroom, every word truly matters. If you enjoy real courtroom cases, legal breakdowns, and the most intense moments from the justice system, make sure to subscribe, leave a like, and turn on notifications so you never miss our next case. Thanks for watching, and we'll see you in the next courtroom.